Hello friends, in the series on the income tax cases, today we will discuss a case where the assessee has filed the form 9A and then the assessee filed the revised form 9A because the assessee has committed some mistake. The issue before the Nagpur I.T.A in the present case was that if the form 9A is revised by the assessee, but this form 9A is not revised before the due date of filing that form, but it has been filed during the assessment proceedings. So whether in that case the benefit of revised form 9A should be given to the assessee. This issue has been taken up by Nagpur I.T.A in the case of Deendayal Seva, Pratishthan versus Income Tax Officer. This case is reported in 126 I.T.A Tribunal at page number 368 and the date of the judgment is 21st March 2025. The present case relates to the assessment year 2020-21. First of all, it is necessary to know the purpose of form 9A. The purpose of the form 9A is that if the assessee is not able to apply the whole income of the assessee as per section 11, that is 85%, then in that case he can file form 9A to apply that income in the next year, and the amount with which the form 9A is filed, that will be treated as deemed application of income. In the present case, the assessee is a charitable organization and the assessee is involved in providing the education and other facilities to the tribal families. Besides, the charitable organization was also providing the sources of livelihood to the suicide victim families of the farmers, etc. For the previous year, which was relevant to the assessment year 2021, the assessee has incurred some expenditure which was capital expenditure. The assessee treated that capital expenditure as application of income, and at the same time the assessee also calculated the depreciation and calculated that depreciation while treating the income as application of income, meaning thereby that both the capital expenditure and the depreciation was treated as application of income. But the provisions of Income Tax Act says that if you have claimed the amount of capital expenditure as application of income, then in that case the depreciation cannot be claimed as application of income. When the assessee made this mistake, the assessee filed form 9A to carry forward some amount, but when the assessee realized this mistake, the assessee calculated the amount of carry forward and filed the revised form 9A in which the carry forward amount was more than the amount of the depreciation claimed, meaning thereby that now the assessee was not claiming the depreciation and the assessee was saying that this amount of depreciation will also be applied in the next year. But the assessing officer did not give the benefit to the assessee for that revised form 9A on the basis that form 9A has not been revised within the deadline of filing the form 9A. The CIT appeal also dismissed the appeal of the assessee. So when this matter was before the tribunal first of all said that filing of form 9A is a procedural requirement, and if the assessee has revised the form before the completion of the assessment, then it should be treated as due compliance by the assessee. The tribunal said that in the present case, the authorities have not applied their mind to determine the correct income of the assessee on the pretext that the form 9A was not acceptable because it was filed beyond due date. The tribunal said that since the form 9A has been filed before the completion of the assessment, so in that case the revised form 9A should be considered to determine the true taxable income of the assessee. The tribunal remitted the matter back to the assessing officer with the direction that the assessing officer should consider the revised form 9A. Friends, this case gives a message that the form should be filed on time, but if because of genuine reasons it is late, then it is a procedural requirement and the delay can be condoned by the assessing officer or the appellate authorities, as the case may be. They should not go very technicalities of the act, and the substantial purpose of the law should be considered. At the end of this video, once again I am repeating the name of the case. The name of the case is Deendayal Seva Pratishthan versus Income Tax Officer, and this case is reported in 126 I.T.A. Tribunal at page number 368, and the date of the judgment is 21st March 2025. Thank you, friends.